This is all, we got a lot. All right, good morning, everyone. Welcome back to House Government Operations and Military Affairs. Today is Wednesday, April 23rd, and we are kicking things off with continued work on S 59, an act relating to amendments to Vermont's open meeting law. And we have counsel with us this morning, so we could really start going sort of request by request from the testimony and stakeholders that we've spoken to and engaged with over the last couple of weeks. And so kind of the goal for today is to start getting a good understanding of how these things integrate into law, if they are addressed, if they are not, and how we could start really honing in these suggestions into amended language. And with that, I will hand off to you, sir.
Good morning, Tucker Anderson, Legislative Counsel. Time for Open Meeting Law Part 2, S 59. We're going to continue working through the requests that the committee has received from various parties about proposed updates to S 59. I'll give you a brief refresher on the requests we've covered so far while Autumn sends me the Zoom link so that I can put the document up behind me. You went through two requests from BAPTA. The first related to the recording of meetings under subdivision A6A of section 312. They requested an exemption for site inspections and field visits from the recording requirement. Their second request was around updating the new requirements proposed in S 59 for agenda items related to executive sessions. That it not only state that there is a proposed executive session that is going to take place, but also include the general topic of discussion in the agenda. To bring you back, because I know it was a long walkthrough of the open meeting law, there is proposed in S 59 a new requirement that whenever a public body is planning to hold an executive session, so they know it's going to happen ahead of time, that they post on their agenda that there will be a proposed executive session. And that's the exact language that has to be used in the agenda according to S 59. That was a policy choice from the Senate. You then heard three further requests. First, to create provisions to exempt working groups or meetings of members of non-advisory bodies to undertake advisory work. To loop you back on that one, because it's going to come up again. I won't discuss it too in depth now. We'll discuss it when it comes up in other contexts. All subcommittees of a committee that are created are also subject to the open meeting law. One of the ways that a public body can navigate some of the open meeting law requirements now is to create a subcommittee that is, under current law, an advisory body. So they don't have decision-making role or jurisdiction over, for example, the legislative matters that the public body oversees, and instead exists only to advise the larger public body. And that would give that advisory body, for example, the ability to meet entirely remotely or entirely in a designated physical meeting location without having to live stream. Okay.
Representative Pistol.
So I'm just thinking, so say a Board of Abatement meeting is public for tax appeal meeting. So that's public, but to go do a site visit would then be an advisory body of the Board of Civil Authority. So therefore, that would not be a public meeting because you wouldn't want half the town tramping through your house to see this. Correct, so the advisory body would still be able, because it's three members. Minimum 3 members.
Your fact pattern is going to get a little confusing for a few reasons. So first, I'm going to caution the committee to, for purposes of the site inspections, not use municipal tax boards, abatement boards, or the Board of Civil Authority as an example, because they're already granted a broad exemption from the requirements of the open meeting law. Those sorts of site inspections have not been subject to the open meeting law for a very long time. A public body might create an advisory body for purposes of site inspections or field visits. But the open meeting law is still going to apply, which is one of the problems that I pointed to last time. So if they determine that for their site visit, it is going to be exclusively a designated physical meeting location, they have to ensure that wherever they're visiting is going to be compliant with Title IX public accommodation standards. That's an underlying requirement of the open meeting law. If they go the other direction as an advisory body and determine to meet entirely electronically, they're going to have to ensure that the site they're visiting has the ability to broadcast to Zoom what they're doing at the site visit. Now, S59 does contain a proposed exemption for field visits and site visits broadly. Proposes to exempt them entirely. There are other concerns that have been raised that we'll get to at the end of the run through this morning. The Secretary of State in a letter to the committee proposed that perhaps these site inspections and field visits be defined in some way. So the last little bit to run through for you all before I pull it up and move to the new stuff. Allowing executive sessions for security, including cybersecurity discussions. I ran through the existing bases under 1 VSA section 313. Strong arguments that it's already covered by some of those 10 existing bases. But if you want to belt and suspender it, make sure that public bodies are assured that they can move to enter executive session to discuss cybersecurity. Is always something you can add to that section of law.
Yeah, I think that's probably, I think we should flag that as something to like strongly consider.
While we're flagging things,
Yes.
it's not exactly relevant to the cybersecurity. So I remember someone asked that we consider adding, requiring people to add to their minutes the length of a executive session.
Was it length or more detail as to the as to why?
There were
was
two
both.
There was
separate,
both.
there were
Okay.
two separate ones, and I think that could be useful information just to add to the list of things that we might be
Okay.
adding.
Yeah.
Just wanted to remind.
So the last point that we got to last time was addressing the, again, apologize for using a brand name, but the Zoom bombing situations where pornographic content is added. Offered to the committee to at some point do a walkthrough of what the definition of a public record is, what constitutes a public record versus what is not a public record. And based both on Supreme Court of Vermont precedent from recent decisions and just the plain language of the underlying law, that content would not comprise public information or a public record under the PRA. So there was, in my legal advice to the committee and the General Assembly at large, because it's not a public record, it can be blurred, redacted, or removed from footage. And I gave examples of where the General Assembly, for purposes of its official records, has done the same and similar in the past to remove objectionable content from our official records. Ultimately, it's material that the public body is likely not producing during the meeting for purposes of public consumption. And although there may be an argument that they are acquiring this information, it does not relate to the business of the public agency at all. Okay, so
That shockingly makes a lot of sense. No. Thank you. Yeah.
there are other examples. We don't have to get to kind of the extreme examples of obscene or objectionable content. But let's say that just someone is giving a presentation to a public body that is being shared, like I'm sharing right now, and there's copyrighted material within there that might be subject to a future claim and doesn't necessarily relate to the underlying content of the record. So there's, for some reason, a picture of Mickey Mouse, which this is a real example of something that was in a legislative record and we got a demand letter from a law firm saying that we owed money for copyright infringement because we were hosting copyrighted images on the legislative website. That can be removed.
Vaguely remember that.
Yes, it happens quite a bit in the committees, especially when third parties are giving presentations. There's sometimes unwittingly very expensive copyrighted material that gets presented and then preserved in the legislative record. Moving on to some new requests here. The Vermont Access Network submitted one request. This is in relation to the recording of the meetings of local public bodies. And the request is to clarify that in the duty to record the meeting, that the municipality can also use third parties to record the meetings. So they would like to add the clause, shall record or cause to record. Legally, this clause is not necessary because there's a duty applied to the municipal corporation, but the language does not specify that it is the municipal corporation itself that has to undergo the recording. So long as they're fulfilling the duty to record, they meet the demands of the law, and that can be performed through third parties. However, if this is something that the committee feels would be clarifying for the public consuming this statute, you can add it, and it's not, in my view, going to have an unintended consequence.
Brett Nugent.
I guess like comment that seems, if it's unnecessary, it seems like might just confuse things later on.
I mean, I guess my question here is like if it's relatively superfluous, it doesn't have a negative impact, does adding it offer clarity to individuals who are trying to understand the statute, how it directs their obligations, right? I think that's sort of the.
Yeah, I guess if it's not there in other instances, then it could cause like misinterpretation of the other instances. That's what I'm thinking.
Yeah. Let's talk about that one more later. Yeah.
But I, of course, will remind the chair of his favorite canon of legislative interpretation. No words that the General Assembly puts in statute are superfluous.
True, sir. Yes.
Behind every word of each supporting
There is intent, direction, and yes, obligation within.
So noted.
The next request is from Lisa Loomis, and I don't know if this was submitted individually or attached to an organization. My apologies, it's just listed as Lisa Loomis on the committee's webpage. These are comments related to the exemption, or excuse me, the executive session basis that was added for information relating to interest rates for publicly financed loans. And the comment or request, the request is that this be removed from S59. And the background reasoning that was provided in the written testimony is that the public deserves to know the interest rate that the town will pay when the town borrows money in anticipation of taxes. And I just want to clarify that this language is about publicly financed loans and the interest rates that are attached to them. This is an executive session when the public body is the entity that is issuing a loan, not when they are incurring indebtedness, which has an underlying law, completely separate procedures, and for almost all instances also requires a vote of the voters of the municipality, which triggers public hearings and things like that. This is about state agencies primarily that issue loans for projects. And as part of the process of discussing those loans is going to discuss the interest rates that are available for the loans that they are.
Yes. Shit.
Do we know why those would need to be confidential?
Some of the information that's being discussed relates to the interest rates that are or will be available from private institutions. And there is hesitancy to have open discussion about the interest rates generally, just because it might expose otherwise confidential financial information.
And that's already something that's covered under executive session.
No, but it is something that would be exempt if this was just instead put in a record that was submitted to the public body. There's a Public Records Act exemption for
Gotcha. So if it was,
confidential business information.
yeah, okay, so if it was provided as a document, it would fall under it. Whereas the discussion is not.
Got it. Thank you.
Excuse me?
Would you repeat?
If the using the interest rates, if those were submitted as a document, then it would stay under the privacy of executive session, whereas, or it would be confidential, right? Sorry, not executive session, but the verbal discussion would not be.
Gotcha.
Yeah.
Just to protect myself in case there's more discussion about this one, the Public Records Act exemption for that sort of confidential financial information is subject to a test. And the test is essentially whether the entity would be put at a disadvantage in competition in the private marketplace because the information is being revealed to the public. And I can dive into that Public Records Act exemption, but if there was confidential business information in a public record submitted to these bodies, they could go into executive session just to discuss that confidential information. And the policy choice that the Senate made and discussed in the Senate Committee on Government Operations around this was just around allowing executive session for the open discussion for the public body of the interest rates. And a policy choice that you could discard. And policy choice.
Yeah, I think I want to flag this one as I don't know what to do with this one yet.
All right, moving into a set of requests and recommendations from the Vermont League of Cities and Towns. They submitted two different documents. One was more memo fashion. One was a PowerPoint presentation where they worked through big picture proposals. They were mostly the same, so I screen captured the PowerPoint because it was a more concise statement of their request. Okay, so for the posting of recorded meetings, they would like to require that recordings be posted to a website that the public body maintains if one exists. And then they had this explanation that municipalities cannot compel private third-party entities to comply with the time frame for posting for public records requests, and this would conform with other types of posting requirements. The Act 133, as it passed out of the General Assembly, there was quite a bit of discussion about where to post and host these recordings and understanding the potential costs that would be associated with, for example, having servers where you're hosting this information. The Senate committee discussed quite a bit about making the options available to municipalities as broad as possible. And the determination would suggest that they would be posted in a designated electronic location. And that solved two concerns. The first was opening up options for storing and preserving to include a designated location, but also ensuring that these recordings were proactively disclosed to the public on a website somewhere that would be designated by a resolution of the local legislative body so that the public knows where the recordings are going to be posted and can go there to find them. And that was married with the understood timeline at the time in Act 133, where the date by which it had to be posted was when the legislative body approved official minutes. S59 gets rid of the approved and official and effectively moves the timing of the posting back to the just posting of minutes to the website generally, which is 5 days after the meeting. So some of that timing for the proactive posting of the recording might be ameliorated here. But it's something to consider, and I would point out that if this is the language the committee moves forward with, there is a proviso in this language. So the duty to post to a website is contingent on the website existing. And there's no duty if the municipality doesn't have a website under this language. So this is pushing the duty not as a mandate, but discretionary upon the municipality. If the municipality doesn't have a website, then they don't have to post the recordings.
Refugian.
Is there like any gray area in terms of like, if there's a municipality that has a website, but it's not, doesn't have a big enough server to host that amount of content or something? Or to-
Not in the language that I reviewed. So
That's
The under- in the
have
un-
any website, you have to post it. Yeah.
something that the committee could consider if you would like to move forward with this proposal. If the recordings are not proactively disclosed, published in a location that's accessible to the public, then the public will have to request a copy of the recording, and that could potentially extend the timeline that they're receiving a copy of the recording or being allowed to inspect the recording of the meeting. And the part of the underlying discussion around these sections was that there was a concern that the public would not be able to view the preceding meeting before an upcoming meeting, so that the public wouldn't know what discussions were had at the last meeting by the time they're showing up to attend the next meeting. There is another thing to note, some of the overlap here is that there are some public bodies that interpret the posting of a recording of a meeting to satisfy all the requirements for posting of minutes, right? Because it's an entire record that meets every checkbox for the minutes. So. The next request, amend public notice laws to allow municipalities to post in public places located in neighboring communities known to be frequented and or allow for a municipal website to substitute one for the required physical public places used for posting public notices when necessary. So a few things to note here. For purposes of the open meeting law, we could be talking about two different things here. So the first could be posting a notice about the location and time of a special meeting. And there are requirements for physical posting places in municipalities where that notice has to be posted. So you could apply this request there. Or this could be referring to the required posting places for agendas, or both. In both cases, there's a requirement for 2 designated physical locations within the municipality where these must be posted. And I don't want to pull it up because it'll mess up the share screen, but it's either for the special meetings or the agendas, there's a requirement specifically that they be posted at the town clerk's office. During COVID and the temporary authority related to the open meeting law, municipalities were allowed to post in designated electronic locations in lieu of physical locations. That didn't carry forward into Act 133, but it's something that the committee could consider, and it is something that is expressly requested here.
Yeah. I personally think that's something we should take a harder look at. Just given the evolution, like allowing there to be like that digital piece, but also maybe some physical requirements.
Do you mean like requiring it to be posted both online and in a physical location, or getting rid of the requirement to post in more than one physical location?
I think that I just in my own head, think like having digital and physical.
Yeah.
Because they
I'm with
just
you.
require, so I mean, so many people are just navigating through like the websites, you know, and whatnot, that they're almost, there's like an expectation of that there. And I also understand that like there needs to be still a physical.
Yeah.
That makes sense.
I also support like allowing a posting in like a neighboring community,
Yeah.
especially for those towns who, like say in Cambridge, you live closer to Fletcher and you go to that general store
Yep.
more frequently than, or those municipal buildings more frequently than in the 10 miles down the road in the village.
Yeah, I mean, I look at my district, where like for Jen's is the downtown hub for like 5-6 communities, right? So I think that's a worthy conversation to have. Yes.
I guess while we're bringing this up, there are communities, like I have one, that there really is only one public place to post a notice. So allowing to be posted in another municipality or electronically is really helpful if there's going to be a requirement to post in X number of locations.
Okay. Flag that for language.
The next two recommendations, which were bundled under public safety and security, we've already run through and reviewed, and those are the cybersecurity executive session bases and the obscene content Zoom bombing. We've also run through this, creating a working group exemption. Again, subcommittees of committees or boards still subject to the open meeting law. Currently, if a subcommittee is created and is an advisory body, it doesn't have to meet all of the broader requirements. Something that I would note particularly for towns is that some of the more burdensome requirements, such as the hybrid meeting requirement, don't apply to local bodies anyway. But still something to consider, and I know that the working group concern has been raised by the LCT and the RPCs. So if that is something that you want to move forward with, we can craft language based around your policy choices. Something to keep in mind, and I will send you a copy of the decision, is that when Act 33 was moving through, and in particular in the Senate, there was a very discrete change to the definition of public body, and it was adding expressly the word subcommittees to the definition of public body, because it used to state that committees of committees were also public bodies, and or subcommittees was added to ensure clarity, because there was a municipality that had created a budgetary subcommittee that was adopting budgets, proposed budgets to be approved by the select board, and was meeting outside of the open meeting law. And there was a court decision just before Act 133 was initially being discussed in the Senate, S54 at the time, I believe. So that informed some of the decisions that were made then.
Do you want to talk about that one for a second? It looks like you might have had words to share.
I am thinking some things, which is that it's the actions of the committee or subcommittee or working group or advisory board that are important, not like the name of it.
You
Exactly.
mean like the charge of?
Right, to say a working group is exempt from blah, 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 that's only works if there's like really specific detail about what a working group is versus.
And when they have been assigned authority, which is really the trigger here.
Yeah,
Right, so one of the ways that public bodies, it's difficult for three-member boards. I will acknowledge that upfront. Right,
We've had extensive conversations about these three-member boards and their ability to communicate and collaborate.
three-member boards, very difficult to navigate some of this. For other public bodies, some of the ways that they navigate open meeting law issues is to assign discrete duties, not formally, but say these members should go discuss this issue and come back and report to the full board. And make sure that that breakout is less than a quorum. They have no decision-making capacity, they haven't been assigned an official duty, and they're not going to be taking any formal action. They're just breaking off
yeah.
to perform some sort of discrete research to come back and present to the body that actually has control and decision-making capacity over the matter. If you structure and create a subcommittee and assign a duty and ask them to take action on it, you have created another public body under the open meeting law.
But if it is a like body mass that does not make quorum and does not make any formal decisions other than a recommendation to the other to the body that formed them, right?
Unless you've created an advisory body where the charge is to come back with a specific recommendation or advice.
But then then it falls under the advisory body designation and definition. It's cool.
Can't we just make some laws regarding three-member bodies specifically, and then everything else would apply to all the other bodies? No?
I mean, we could.
I'm just throwing it out there.
No, I gotcha.
Because whenever we talk about this, that's the one situation that we're trying to manage
Yeah.
in an appropriate way so that they're able to do their work, but that also they're not able to make decisions within and violate public open meeting law and make sure that those decisions and discussions are public. Just thinking.
No. I like thoughts.
Yeah.
Rep. Nugent?
Well, it seems like, yeah, you have a subcommittee that's acting almost like a staff to the larger board in a way, like going and doing research and bringing back proposals rather than making decisions. That if you had a three-member board that was doing that, it's like, 6 of one or half dozen of the other, just the same thing. Like they don't need to have exemption from open meeting law to do what they would be doing anyway, because they're all together, I guess.
If you do have policy decisions that you want to make around certain types of boards, three-member boards, later on, we'll cover some requests from state agencies where the board is charged with discrete administrative day-to-day duties, including supervising staff. I can provide recommended language on how to navigate whatever policy choices you want to make. And one of the things that I noted in the Senate is that perhaps this could also be boiled down into guidance for the General Assembly in the future when you are creating working groups, task forces, working on the statutes related to municipal government, where the guidance states that, hey, the open meeting law is going to be difficult for this three-member tax commission to navigate because you're creating a panel of experts that can't deliberate or discuss any of the issues that they're supposed to be expertly analyzing until they turn the camera on Wednesday morning at 9 o'clock and give themselves 90 minutes to do a week's worth of work. It's also something I mentioned in the Senate, an opportunity to examine whether or not these duties should be assigned to an officer instead of a board. Officers not subject to the open meeting law, public bodies subject to the open meeting law.
And so that, as defined within the context here, the officer would be an employee? Or-
Yes.
Yes.
So, and another option would be to expressly grant authority to the public bodies to assign duties to, for example, an executive director.
That's interesting. Let's talk about that one more later.
Okay,
Without the planning.
Yeah, no, totally. I like the assertive drawer pull on that one. That really speaks to the intent.
It was more about what I intended, but
the Secretary of State submitted an entire memo and the individual proposals within S59 and some of the discussion that has come up so far. I tried to pull out language that formed a recommendation outside of what is already in S59. And this is the one that I pulled out. So my apologies if there are other things in there that were discrete requests that I missed. So it states that SOS supports excluding statutory site inspections and field visits. So as distinguished from just broadly exempting site inspections and field visits. I don't want to read all of this, but they recommend restricting it to site inspections and field visits that are mandated by statute and or those that occur as part of a quasi judicial proceeding. They also recommend clarifying that the public body may not take testimony, admit evidence, or make any decisions during excluded site inspections or field visits. And finally, they suggest considering extending a similar exception for municipal public bodies with regards to electronic recording and posting requirements for purposes of field visits. So right now, the field visit exemption is tied to the hybrid meeting requirement in S59, but doesn't extend to the recording of the meetings of public bodies at the local level.
I gotta read through that again.
First recommendation,
Yeah.
tie the site inspection and field visit exemption to statute so that I am building the plane as I fly, but that would be something along the lines of field visits and site inspections required by state law would be how the exemption would be phrased, for example. That's recommendation 1. And or those that occur as part of a quasi judicial proceeding. Further, they recommend clarifying that during these visits, they may not take testimony, admit evidence, or make any decisions during the site inspection or field visit. So essentially no action.
No action yet. I think that's a fair caveat, if we go here.
And then finally, taking whatever that exception is built into the hybrid meeting requirement for state public bodies and adding it to the recording requirement for local public bodies so that site inspections are not recorded.
Okay. I think that actually this speaks to a lot of the feedback that we received from a range of folks that I see.
Yeah. I immediately forgot it after you said it. You said, sorry, I was just thinking about it. So we're saying they're not allowed to make decisions on the site visit? And what were the other things? I can't see that part. I'm just blank.
Can I advise you?
Yeah, you are really testing the boundaries of my poor
Oh,
eyesight.
there we go. Okay, I know. We've got the nearsighted duo over here. I can't see anything. Okay.
And don't forget my epic stigmatism. Please proceed.
Site inspection and field visits.
Okay, this is the part. May not take testimony, admit evidence, or make any decision.
Correct.
But they're allowed to discuss.
Yeah, deliberate perhaps, which is a
Okay.
defined term for the open meeting law.
Deliberate, but
Say they're deliberating for the public meeting?
It depends on how deliberate they're going to be about their deliberation.
But I think either way, when the body posts their minutes later on, they give a recap of what they said, what they did, what they talked about, what they saw, which might hopefully loop in that deliberation.
So if they were discussing it on site, then it would be as part of the minute.
Captured.
I believe so.
Okay. Because that's
But
the
even
important
if they
part.
make any decision, they would still have to recap the conversation while they're making the decision in the formal environment that's being
Yeah.
recorded.
Yeah, you'd think that like say at the next meeting, they're making a decision about something related to the site visit, that then they would talk about the discussion.
I got feedback from the gallery.
That would be submitted as testimony by the official, what,
Could you identify yourself for the
sorry,
record,
for the
please?
record, Samantha Sheehan from the League of Cities and Towns. We support this language, I think we presented the same.
Yeah.
Caveats, and so if the official, like if the zoning administrator administers a site visit, they would return to the body and then they would submit their observations as testimony for the body to discuss on the record.
Thank you.
It might be helpful as well to outline what site visits are actually subject to the open meeting law at this point and what would be covered by the additional exception. And something to note mechanically about the way that S59 is currently drafted and the way that it would continue to be applied with this construct, the open meeting law would still apply to these meetings. It's just the hybrid and recording requirements that would be accepted from these sort of visits. So
Okay.
something to consider is that the way that is currently constructed, and you can change this, is that you're setting aside the hybrid requirement over here and potentially the recording and posting requirement here. Hopefully my over here's made sense.
It did, yes, yes, it's clearly delineated.
It determined the delineations during a site visit of the here's. Okay. Vermont Housing Finance Authority submitted a actually quite discreet proposal of amendment, but it goes in the opposite direction of what you just considered from the Secretary of State. And that is to expand the site inspection and field visit language to apply to gatherings of a public body that include a site inspection or field visit. So adding that include language means that for the entirety of the meeting, there's no hybrid meeting requirement or whatever is happening, not just the site inspection and the field visit, but the gathering outside of the site inspection and field visit would also be covered by the exception.
So this means that if there was, let's say, a select board meeting that included a site visit, this language would mean that when they went back to town hall and conducted their meeting, that would be exempt?
No,
Okay,
but that would, so in that case, you would effectively have an adjourned meeting at the time they leave the site inspection or field visit.
Oh, so you don't have to like adjourn, getting
and then it's
vehicles,
a different meeting.
return, reconvene.
This would cover, so I don't want to assume what is being considered or proposed here, but based on the testimony you've received so far, I think that this is getting at the retreat issues.
Yes.
Which were brought up by multiple different state agencies. And is intended to cover everything around a particular site inspection and field visit. To remove, again, just the hybrid requirement. This isn't an exception from the open meeting law broadly. But to your question, Representative Waters Evans, it could potentially include, for example, the site inspection and the field visit. And while they are at that designated location, holding a meeting and taking action. There might be other complications in the underlying open meeting law with doing that, but
And that would, any example on that, like how that would go into?
so if the location that you visit, for example, and I brought this up so many times, I'm sorry for being repetitive, but if it doesn't meet the Title IX accommodation requirements
Yeah.
for this bumping location, there's likely an argument that a member of the public could make that they were excluded. And the exclusion of a member of the public is one of the strongest bases for challenging actions taken by a body as a violation of the open meeting law. They have to actually prove that they were excluded. That's based on a decision related to the city of Burlington from maybe 4 or 5 years ago, but
About 4 or 5 years ago, that would have been like deep in the middle of.
I believe it related to, if I'm remembering the fact pattern correctly, an automatic locking door. And the complaint was that in theory, that automatic locking door and the site used by the public body excluded members of the public wrongfully from the meeting. But there was a failure to demonstrate that anyone had actually been excluded in fact. I'll send a copy of that.
Gotcha. No, I was just putting that together. I think I see what you're saying. That series of events. Yes. Okay. Oh my God.
Okay.
Of GovOps. Let's keep going.
VCUDA, I'm assuming that's the Vermont Communications Union District Association.
Mhm.
Yes. Their request is for A to D to clarify that a public body may hold electronic only meetings if it includes 5 or more towns or 2 or more counties. And that these public bodies shall only be required to provide access to a physical location when a request for access is received by the public body. Policy choice for the committee to make. And communications union districts, of course, would not be the only entities qualify under this exemption, just based on the criteria in that clause. The public body includes 5 or more towns or 2 or more counties. That language might need to be tightened up a little bit, but in all likelihood, you're also talking about all of the RPCs here. You're talking about many of the school districts. So if this is something that the committee wants to move forward with, making the policy choice about whether this is applying exclusively to communication union districts or whether this is intended to also apply, for example, to the Northeast Kingdom Solid Waste District, which has 43 member municipalities, if I'm remembering correctly.
If you're not correct, you're close. Yeah, so this would obviously ripple into those other entities unless we specify that it is for the CUDs.
And yeah,
Yeah, okay. All right.
and to refresh your recollection, anytime this references, any of these requests reference A2D, that's the requirement for a designated physical location when members of the body are meeting electronically.
Mhm. You know, one of the things we heard in testimony from those folks is like, there's a perceived burden for setting up the location. They're seeing like little to no like actual like human contact. Nobody's actually showing up in body mass. So it's sort of the how much effort's going into the execution of that charge, that requirement, and actually seeing participation in that manner. Rep. Nugent.
Yeah, that makes sense from their end, but yeah, that seems like a big exception that would apply to a lot of other.
Correct. And I guess that's the policy choice, is like to be isolated to this particular entity and leave others existing as current law requires. So I don't want to make any choices today with so much body mass not being here from the committee, but let's definitely flag that as like, I think considering that carve out is kind of where I'm leaning towards right now. But I don't want to make any type of firm decision. Boyd?
Yeah, no. I feel like it's not appropriate to call them out specifically in statute, but if we look at the size of their bodies and figure out what size organizations could be part of, yeah,
Yeah, I see what you're saying. So like as far as just more like structure of the organization or.
yeah, go ahead.
So that it's a law that like applies, that's not like a carve out for an entity, but it would just narrow the scope of like who would fall under it, so it would be unfair. Yeah.
Okay, that one's definitely flagged for further discussion.
Narrowly tailoring the language without calling out the specific entity. Yes, that is likely what this was attempting to do, just because it applies broadly and not specifically to the CUDs, but you could make it more narrow in order to exclude certain types of districts.
Taylor, yes. Like bespoken statute now.
Always bespoken.
Always be bespoken.
Always be bespoken. Speaking. Sorry.
Are we ready to move on?
I'd love to, yeah.
Excellent. So the town of Brattleboro has submitted two separate requests at varying times. So the initial request was to exclude representative town meeting from the definition of public body, which is something that S59 as introduced had in the bill, and it was taken out by Senate Government Operations after some extended discussion with the town and consideration of the existing provisions of the open meeting law. Subsequently, the town very recently submitted the following language, which is a proposed amendment to 1 VSA 312 subdivision A3, which is the hybrid meeting requirement for state agencies, state public bodies. So just going to read that up front. The language they sent, state public bodies. And then down below, an exception for annual meetings as authorized under 17 VSA 2640 and 2640A, representative town meetings and then annual meetings broadly. This subdivision applies the hybrid meeting requirement to public bodies of the state. Not only does it say it in the subdivision heading, it also says it very clearly in the opening clause, any public body of the state. It was part of the discussion around differing duties between state public bodies and local public bodies, that the hybrid meeting requirement was going to apply to public bodies of the state because they were presumptively better resourced to do that. This request doesn't necessarily make a lot of legal sense, and if added, would likely add confusion to the statute about whether or not the subdivision does apply to local public bodies. Why would you grant an exemption to a local public body in the subdivision unless you were insinuating that it applies to local public bodies? One of the things that the committee may consider, just because some municipalities appear to be confused about the application of this subdivision, is make it even more express. And we can craft some language, perhaps a sentence that says this applies exclusively to state public bodies.
I think that sounds like an efficient path.
Great.
Yes. Cool. We'll add that to the amended language list.
Any further consideration of this one? This is all existing. It's the site inspection and field visit.
Okay.
There was one other late breaking request, and that was from the Land Use Review Board. There weren't any specific proposals that came up for amended language, but I believe that the committee has the requests and written testimony from, I will call them LURB, because that's just the nickname that I have heard thrown around the building. The LURB situation, along with a few other state public agencies, all individual policy choices for the committee to make around whether you want to grant specific exemptions to those state agencies from specific requirements in the open meeting law broadly. My understanding of some of the concerns from LURB is just that it's difficult for that particular public body to carry out their day-to-day business under the open meeting law broadly.
And that's a result of just being so like sort of site visit centric or.
It is a result of being a public body that is tasked with discrete expert decision-making duties.
Okay.
And it's one of those instances where the General Assembly could attack this in the open meeting law with specific or broad exemptions, or in the statutes that govern LURB or the other public bodies that have concerns about operating under the open meeting law. And brought up some examples earlier, assigning duties to officers instead of bodies, adjusting quorum levels, raising the quorum level, for example, makes it so that small groups of public bodies can deliberate on certain issues without triggering open meeting requirements. The counterbalance is that it makes it potentially more difficult to actually hold a meeting where you can take action when the quorum requirement is higher. So for example, if the quorum requirement for this committee right now were 8, so one other thing that I wanted to note on this general subject, because it has come up quite a bit, both in the Senate and expressly in testimony before this committee, was a request for broad exemptions for specific state agencies, based on the assertion that the only reason they're captured by the hybrid meeting requirement is that they are interpreted as having a budget, and that their budget does not consist of public funds, that it is all non-state, non-public funds. I did individually research each one of the agencies that appeared before you to make those statements, and was able to identify multiple appropriations, especially over the last 20 to 30 years, of state funds directly to each of those agencies, comprising in total $30 to $40 million over those couple of decades. Additionally, financial ties between the state, where the state is obligated in varying forms to cover debt, for example, incurred by those state agencies. So all of this, again, policy choices for the committee to make. And drafting the exemptions for those particular state public bodies and state agencies, very easy. But I didn't want the inaccuracy of some of the testimony to sway your policy decisions. And I'm happy to send you copies of each one of those appropriations. They were not difficult to pull up.
Understood. Okay. So for next steps, I think I wanted to like independently run through the notes with some of the members as we start to hone some of this stuff in after going through that with you. So that would be probably the next course of action. Rep Hango.
Are your notes available to us, Tucker?
The document that I was going through,
Uh,
yes, and I will again note, I failed to note it this time. I did note it last time. All that I did was screen capture the individual requests that are already on your committee page. But I'm happy to title this document and send it to Autumn so that she can distribute.
Rep Hango took the words out of my mouth. I think that would be helpful for us to just sit down as a group to just digest, even though it is a little informal. I think it is a good resource for us to work on. So.
So to further request, is there a way to do a side-by-side between the requests and what currently exists?
I can prepare a side-by-side for the committee.
Is that out of line to request? That would be very helpful. And And then the last thing is, I recall I asked about the names, like non-advisory and advisory. And last year when we were working on what became Act 133, there was a chart that described what a non-advisory and an advisory, state level and local level. So it was like a 4-quadrant chart. Do you recall the chart I'm referring to?
I was on paternity leave at the time, but I did watch your committee, because that's how lame my personal life is. And I believe that the chart you're referring to, it's still going to be on the committee's page from last biennium. It was prepared and submitted by Senator Ruth Hardy.
Correct. And is it accurate to the final version of what became Act 133? I think that's where I was going with this.
I would have to go back and look, but yes, it largely will be accurate.
I remember it being like a grid. Maybe Autumn could look for it for us and send it to Tucker to see if it accurately reflects what a local non-advisory body is, for instance. That's great. Thank you very much. Appreciate it.
Happy to take a look at it again.
Thank you.
I think I've noted this for the committee before, but if I haven't, all of these terms you can change. You can come up with better names. You can use whatever terms you would like. If advisory body is not what you would like to move forward with.
And I think we've heard that in testimony from various groups who have been in to request changes, that it is quite confusing for the general public.
Non-advisory as a term is struck in S59 to try to address some of that confusion because it was never a defined term for purposes of the open meeting law. It was added in primarily in the subdivision headings as an attempt to give, in particular, this committee guidance on how to use the chart. It was submitted by Senator Hardy to understand where each individual subdivision matched up with the chart.
And so one of the reasons after the floor today, I was hesitant to schedule any formal testimony is we've got this particular discussion to have, as well as a few other bills that we're honing in right now. So I was leaving that space open for us to work on those as individually assigned members to those bills. So that's why you're seeing that gap in the schedule with nothing formally there, because it's going to be a lot of working product study hall, shall we say. Do we have anything else for council right now in this moment?
No.
No. Cool. We did push out the work on the grants bills till 11, not knowing how long this was going to take. So we'll take a little break. We'll start gathering some documents and have some discussions around this stuff informally. And we will be back on at 11 to take back up H233 with some amended language to review and hone in.